Sir, Professor Venkat Rao sir will share her words, his words and wisdom.
Now, I would address you because these little angels are law students now on the rolls, and ever since we have walked from the university to universe, we have started being students of law, and that process goes on. And the participation in this afternoon's conference is a part of that exercise. Be that as it may, it's a privilege and honor for me to have been invited to chair the first technical session. My focus would be on the little angels 21st century students as to how they have to chart out the future, because to use the cricket metaphor, we have already started the second innings in a 5-day test match. And the little ones are yet to face the first ball in an unlimited test match. Now, conferences like this, I must congratulate the BHU people, because after a gap of 50 years, I'm seeing such a mammoth conference, a judicious juxtaposition of law students, law academics, juries, judges, and others. And it is an epoch-making effort. Two things, young minds, please remember, as to how this conference is going to be a deferred dividend for you is, remember two fundamental lessons in life. Number one, today's knowledge is tomorrow's ignorance. And number two, in the real life, in a race for excellence, there is no finish line. There is only the commencement line. Why I am stating that is, the race for excellence in legal education has begun, but only little has been done. Vast remains to be done. And what is that is required to be done? My appeal to my senior colleagues here is to bestow attention on a very interesting point. If you look at the developments in modern education, you would come across a term called STEM, S-T-E-M, science, technology, engineering, and mathematics. And parents always loving to send their children to one of these four disciplines. Do you think that time has come for us to have a Banaras declaration whereby this abbreviation STEM must include L law also? Please remember, take the initiative, and I would say from now onwards STEM should be called either SMELT, science, mathematics, engineering, law and technology, or it must be called MELTS, mathematics, engineering, law, technology and science. If by the time the valedictory session is on, if there is a consensus, and if Banaras can have a declaration that the time has come for us to switch over to law. Look at Professor Mitra's point. When something was going on in the realm of petroleum, there were no qualified lawyers who were having technology and specialization, and lawyers were required to be imported. And 21st century legal education is going to be legal education and not in isolation. Remember, it is going to be a blend. I'll come to that later. I'm reminded of senior advocate Parasaran's classification of lawyers into two types. He said, in India, lawyers can be classified into starved lawyers and starving lawyers. The same metaphor can be extended to legal education. You can say starved law schools and starving law schools. You can say starved law faculty and starving law faculty. You can say starved law students and starving law students. And maybe because the conference is late today, starving participants also. Remember. Therefore, what is the dichotomy in the legal education in India today? And can we apply a one shoe that fits all sizes formula for legal education. You must think about that. As the chairman, I will be raising certain questions for you to deliberate on those things. First question is, can there be a universal formula? What is the point in teaching intellectual property and patent laws to a law student from a law college situated in tribal region in Chhattisgarh? Agricultural laws, land laws, and others will have more meaning for him. Okay? And therefore, should there be multitasking? This is the first question that I am going to raise. And next issue I would like to raise before you is certain bad things that have been happening in the United States of America that also had a cascading impact on legal education in India. I am directly referring to the last point in the theme that is allotted to us about ranking of law colleges and law schools, to what extent they are relevant. I would say this has been imported to India from United States. In the United States, very interestingly, in 1975-78, a very interesting thing happened. And that was starting of a journal by name The American Lawyer by Stephen Brill. Young students, this is very important for you. In 1979, he has started a magazine called American Lawyer, the primary purpose of which is to cover the business of law firms, lawyers, and legal education. He has used the word business of legal education. And in 1975, in the United States, in lawyers' offices, a new trend started called billing per hour. They keep a stopwatch. When a client comes and start discussing with the advocate, they start the watch. When the discussion is over, suppose it is 75 minutes, they say for 75 minutes you are required to pay so many dollars. This is called billing per hour that has started in the United States. And in India, it started 10 years ago. Top advocates started charging billing per hour. And number three, in 1985, the ranking of law firms started in America, 85. And today, 250 law firms control the entire legal system and administration of justice in America. And in 1987, ranking of United States law schools began. So what began in 1987 in the United States had a cascading impact on India. And in 2012, a book was published. The name of the book is Failing Law Schools. The author is Brian Tamaha. I'll be organizers to circulate list of 4 books, which any student volunteer can take it. Okay. Yes. This can be circulated among the participants. What I'm trying to bring to your notice is, in this book, Failing Law Schools, Brian Tamaha says in the United States as to how the law schools have cheated the students by giving false advertisements and by being parties and privies to false ranking system. Okay. With the result, in 2017, 3 students in the United States who graduated in law filed suits against American law schools claiming damages, that you have promised falsely that we'll be getting high quality jobs. We have taken bank loans of $1 lakh and nothing is on the horizon. So you are liable for it. You have raised false expectations with us. The matter was dismissed by the court, but the court said This is a thing to be watched for in the future. This is because of artificial rankings, remember, and then sprucing up the rankings, inflating them with false data. And what has happened in United States may happen in India in another 10 years with the growth of law schools. Please remember that. Therefore, what is that we are supposed to do as far as legal education and ranking are concerned? One more issue that was asked was about accreditation by the Bar Council of India. It is a non-starter. And they have handed it over to NAC, and NAC also is now changing the rules of accreditation totally. Total grading system is removed. Either you are accredited or you are not accredited. This is going to be the future. Therefore, we need not throw much focus on that. And then the next point I wanted to share with you is, right. What is that you need to teach a law student? Are you required to teach law student? The question, is it lawful or is it moral? Most of us teach the question, is it lawful? Which Professor Mitra was speaking about value education. And Shakespeare in the Merchant of Venice said, a lawyer should not only have a functioning brain, but also should have a functioning heart. Now, how many of the law students that we are churning out from national law schools have functioning heart? Now, are the law schools being treated as incubation centers or transit camps for work camp place? Or are you teaching values in law schools? Ask for ourselves the question. This is the third issue I wanted you to deliberate if you would like to speak about the future of legal education. And then, when you speak about rankings and QS rankings, world rankings, all of us in one voice complain that the questionnaire is biased towards the Western countries. The questionnaire is totally biased and it is not in tune with Indian educational system or ethos. But let me ask you one question very frankly. NIR ranking questionnaire, is it not biased towards the elitist law schools? Is it not biased towards the elitist law schools? In the sense that there is a question relating to perception. And I have seen among the 100 participating colleges in NIRF, 80% of the law colleges which are on the periphery getting 0 in perception. Whereas a national law school like Bangalore gets always 100. And that 100 out of 100 changes the skills, okay? And therefore, is NIRF ranking also biased towards the elitist law schools? Number 4 is, are national law schools being pampered a little more? Because whenever you speak about reforms in legal education, I found in my last 10 years of experience, I was for 10 years Vice Chancellor of National Law School, Bangalore. And then I moved to Goa. Whenever reforms in legal education were mooted, the same set of dramatist personnel will be there in the conferences. Who are they? The Vice Chancellors of National Law Schools and the directors of premier private law schools, maybe Symbiosis, maybe Global Jindal, but not even a single Casabianca from the periphery. Now, if you are really interested to bring about reforms, my sincere advice to the regulatory body, Bar Council of India, which has been doing reasonably good work, is to call for a meeting at the micro level, ask your district bar councils or the state bar councils to invite the local colleges and their principals, the so-called law colleges in the mafsil areas, okay, and discuss with them what are the problems of the faculty. Are the faculty being paid anything? J.S. Mann always has a complaint that faculty is not paid even a pittance, and you talk about reforms, okay, isn't it? But who is hearing them? For you, the faculty means only national law school faculty. Please remember, legal education may begin in national law schools but does not end in national law schools. There are 1,721 law schools in India. And just as somebody said, judicial reforms do not mean reforms only for Supreme Court and High Court. It must percolate down to lower courts, where 90% of litigation is. 90% of the law students are in the periphery. Now, have you heard about them? Now, have you heard about the grievances of the principals? Have you heard about the grievances of the faculty members? Make each district bar association or state bar councils responsible to convene meetings at the micro level, collate information, give that information to Bar Council of India so that meaningful structural reforms can be brought about in the most important sector of legal education. Till you do not do that, it will be like, remember what is called, Ambedkar said, cosmetics on a dung heap. And therefore, try to apply your mind to this particular, especially I wanted to focus on this. Number one, value-based education. And number two, focus on law colleges in mufti areas. The third one, the sooner you do away with the ranking system, the better it would be. Ranking system has resulted in all sorts of distortions. And when an institution does good work, it doesn't require recognition by somebody. When BHU had been doing such an excellent work from 1960s, its students were its ambassadors. When Campus Law Center, Delhi University were doing excellent work, its students were its ambassadors. Nobody need to say you are number one, number two, number three, and for that number one and number two, number three, all sorts of dodging information has started taking place. Remember, including, I should say, the attrition of the faculty from some schools, okay, and therefore, the sooner you get rid of it, otherwise the same fate that has happened in the United States, where students have started suing for law schools, as recalled in Brian Tamaha's book, Failing Law Schools Will Happen in India. Therefore, this is a momentous occasion for us to reflect, because this is an honest occasion for self-introspection, remember. Now, conference's primary objective is to remove complacency and to make an honest self-introspection. Because always remember, in life, good judgment comes out of experience, but experience comes out of bad judgment. And conferences are meant to analyze those bad judgments so that the future legal education order will become more equitable and more just, in keeping with the constitutional goals of justice education. Now I leave the floor to my colleagues, because we are running short of time. Yogesh Singh and Nirmal. Thank you very much.
Thank you, sir. You have very beautifully and briefly delighted us about certain challenges, specifically the impact of US on the legal education. With these words, I once again thank you and humbly invite Professor Singh to share his views in brief.
Respected Chair, Professor Venkat Rao, respected panel members, Professor V.C. Nirmal, Professor Dharmend, all the delegates, students, I am grateful to Faculty of Law, Banaras Hindu University for giving me this opportunity to share my views. And I concur with Professor Rao that after so many years, this kind of conference is being organized in country. At least I have not seen this kind of mega event, and I hope that it will be a serious event and some outcome, because if we see the history of legal education and reforms in legal education, there are so many reports. 500 reports we can find out from Google, starting from 1920s, 1930s. And all these legal reports raise serious concerns on the status of legal education. You will not find many good points. So all these reports talk more bad points about the legal education. So there is a serious anxiety on the status of legal education over the years, and I hope that this conference will give some kind of outcome resolution, as sir mentioned, Banaras resolution, something we can give. And the theme of this session is promises and prospects, reforms in legal education, governance. Professor Mitra in his keynote address raised some points on the promises and prospects of legal education. I thought that I will raise some of the concerns which bothers me. As part of legal education, I have been working in national law schools for around 15, 17 years. And I find that accountability is one part which is, or which we don't talk in the conferences, which we don't mention in the reports, which we don't ensure the accountability of the stakeholders. We have thousands of pages, reports, committees, commissions, Supreme Court judgments. So even Supreme Court judgments have raised serious concerns on the declining standards of legal education. But in spite of that, Supreme Court, if we ask this question, that what measures Supreme Court has taken as the highest court of the land, and what is the accountability of the Chief Justice of India? He is the head of the Indian judicial system, and he is also a stakeholder in the judicial system, legal education. As a matter of fact, Chief Justice of India is also chancellor and visitor in many of the national law universities. So there is a specific statutory duty also. Not only with respect to convening the meetings of the governing body and chairing the meeting of the governing council, but the overall reform in the legal education and national law university system. Sir rightly mentioned that we have 1700 law colleges, 1700 law colleges. There is no doubt on the fact that national law school concept raised the standard and the quality of legal education. But how many? 25, 26 national law universities, how many seats, how many students study in national law schools? And then there will be some law faculties like BHU and Aligarh or Delhi University or maybe Allahabad University. But what about those 1500 law colleges, law schools which are there in the country, and how these law schools, law colleges got affiliation from the Bar Council? Because Bar Council has to ensure the minimum, and that minimum is so minimum that we confined only to the minimum. We don't talk about highest standards of legal education, quality legal education. We are only talking about minimum standards of legal education. And unfortunately, we could not maintain even that minimum threshold which Bar Council has prescribed. What is the minimum threshold for a law school, law college? Is very, very low, very less. You spend 5 lakhs in the library, you appoint 3 contractual teachers, and you have some even rented space, you can start a law college. And how these inspections are made, I have experienced in last 10, 15 years. I have been part of the inspections, and what kind of deliberations are going on or made, it is I think less said the better. There are cases pending before the CBI court, there are cases pending before the high courts where the Bar Council members have been prosecuted. The Bar Council has been given this responsibility to bring reforms in legal education and set the minimum standards in consultation with the universities or institutions of the legal education. But how many times this consultation happens, whether we ensure, and that's why I said that accountability part we don't talk about, whether it is accountability of the Bar Council, whether it is accountability of the Chief Justice of India as a stakeholder, whether it is accountability of the Government of India as a stakeholder. Government of India has least interest in legal education. We only claim that we have NLUs when we started that these are the IITs of the law, IIMs of the law. But claiming IITs of the law and IIMs of the law will not make a difference. How law university is being established, I have seen as a founding member, and now I am seeing as an important stakeholder in Tripura. It's a very, very difficult process. Nobody cares. What is there that some accountability of the Chief Justice of the High Court, because most of the law schools are being now headed by the Chief Justice of the High Court. They are the Chancellor. So one Chancellor will impress that there should be a law university in the state, and the act was passed and the pressure of the Chancellor, but there is no money, there is no infrastructure, there is no vision, and the law school has to start, law school has to function. The Chief Justice retires, new Chief Justice will take over, he has his own vision. So there is no accountability on the part of the Chief Justice of the High Courts, who is working as in the capacity of the Chancellor of the many national law universities. Accountability of the Vice Chancellors. We often say that NLU system became a VC-centric institution. And it's true up to a certain extent. Because for many years, many law schools did not have even service regulation, leave regulation. So everything will go to the Vice Chancellor, and it is at the mercy of the Vice Chancellor. He will approve or disapprove or whatever. Every law university act, National Law University Act, provides that there will be a review commission after every 5 years. Is it not accountability? It is not responsibility of the Chancellor or the visitor to ensure that after 5 years the mandate of the act has to be fulfilled? How many law universities have review commissions till now? No, we have 27 national law universities. Bangalore has 2 review commissions. Third one is recently constituted. NUJS got commission in 2016, after so many years of the establishment and functioning of the NUJS. Gujarat National Law University got 1 commission in all these years, and Nalsar got 1. And most of these commissions were constituted not suo motu by the Chief Justice. When there was some kind of pressure, some kind of incident, something pushed, then this commission was constituted. And if you see the report of these commissions have not given a very progressive and positive reports on the functioning of the national law schools, so-called the islands of excellence in legal education. I have read the reports of NUJS Review Commission. I have gone through the report of Madhav Menon Commission on GNLU, Gujarat National Law University, and the Nalsar Kadri Commission report. Very negative report. But what happened to these commission report? Many law universities are functioning from last 15 years. They don't bother. They don't bother that they have to constitute a review commission also. Even in Odisha, I was the registrar, and the previous Vice Chancellor left, and I got opportunity. I was made in charge Vice Chancellor, and I requested Chief Justice that we should constitute a review commission because it has already been 15 years, 13, 14 years. And the file was pending. He said that no, the new VC will come and then we'll discuss and we'll constitute review commission. It is almost 4 years, but review commission has not been constituted. So we don't talk about accountability in the legal education system. I already mentioned that Government of India has least interest in legal education reforms. We got a new education policy, and with new education policy, we have only 1 or 2 paragraphs on legal education, which is, Professor Mitra said that at least they started legal education, they have mentioned in the education policy about the legal education. But Government of India, in my opinion, they don't take legal education, not only legal education, they don't take judicial system seriously, because this does not affect their electoral prospects. We have very few, limited number of judges in the country. The Chief Justice of India will keep on asking the government to appoint more judges, not only in the High Court and even subordinate courts. But it is the least, I'll finish, least priority, because if judiciary is not functioning well, nobody blames government. We are running behind the schedule, so I think I should restrict. My concern is that when we organize seminar, when we organize workshop, when we constitute committees, we should ensure on the part of the accountability what will happen, who will be responsible, who will be accountable for what. So we should fix the accountability of the various stakeholders in the legal education system, otherwise situation will not improve. We have already so many reports, and this resolution and this report will also add to that literature, and it will go to the dustbin. So we should focus on the accountability part. So thank you very much for giving me this opportunity.